All right, welcome to segment 3 of our asynchronous lecture. We're talking about agency and we're starting with the case of Gorton v. Doty. So, why are we talking about agency? Agency is a fundamental fiduciary relationship, absolutely fundamental. The restatement of agency in the very first section says that agency is the fiduciary relationship that results from consent by the principal to the agent, that the agent will act on the principal's behalf and subject to the principal's control. Right? In agency relationships, the principal is responsible for the acts of the agent as if the principal carried out those acts herself. Right? Let me say that again. In agency relationships, the principal is responsible for the acts of the agent as if the principal carried out those acts by herself. So a finding of agency is critical for liability, right? Liability will turn on whether a person is considered a principal who directed the acts of another, the agent. If there's an agency relationship, that principal will be liable. But deciding whether somebody is an agent ex post, right, looking back, that's very hard to do. And that's what we're talking about with some of these cases. When can it be said that an agency relationship exists and that therefore the principal will be liable for the acts of the purported agent? So the first case is Gorton versus Doty. Richard Gorton, who was a minor, is suing Charlotte Doty through his father to recover for damages for personal injuries and for hospitalization expenses. Right? So what happened in this case? It's September 1934. Richard, who was a junior at Soda Springs High School, had a game against Paris High School. Doty is a teacher at the school, and Russell Garst was the coach at the school. Doty knew the team was playing in Paris, and because she wanted to be helpful, she volunteered her car to be used to transport the kids back and forth from the game. So she asked Garst if he had enough cars, right? And Garst said they actually needed one more, typical scenario. And she said, okay, you can use my car, but only if Garst does the driving. You can use my car, but only if Garst does the driving. The question in the case is whether Garst was Doty's agent while driving her car from Soda Springs to Paris and back, right? Because, of course, if Garst is Doty's agent, then Doty, as the principal, is liable for Garst's conduct. The plaintiffs claim just that, right? That Garst was acting as Doty's agent, and Doty is therefore liable as a principal for what went on while Garst was driving. So again, the case says agency is the relationship that results from the manifestation of consent by one person, the principal, that another person, the agent, will act on the principal's behalf and subject to the principal's control, and there's consent by the agent to so act, right? So you need two things, right? You need somebody acting on behalf of another and subject to their control, right? Those two prongs are crucial for agency. So what is the court's reasoning in this case? Right? Doty clearly could have driven the car herself, the court says, but she designated Garst as the driver, and she made it a condition that Garst do the driving. Right? So she therefore consented that Garst would act for her and on her behalf, and by driving, he basically consented to so act. Right? So he's the agent, and she's liable as a principal. She claims this is nuts, right? This is completely crazy. She says this was just a loan of my car, and this whole business of a principal-agent relationship makes no sense. So the court goes back and reviews the testimony, and it fixates on the last statement by Doty when she says, I said that he might use mine, meaning use my car, if he drove it. That was the extent of it, right? You see this on page 140 in the second column. So, by saying that was the extent of it, she, the court says, essentially summarized the entire agreement, right? Garst acted on her behalf and subject to her control because she herself said, right, I said he might use my car if he drove it. That was the extent of it. So the court, interestingly, finds a fiduciary relationship. The dissent by Judge Budge is something we all might sympathize with, right? Judge Budge says there is no evidence here that Garst was really an agent, right? Agency means more than passive permission to do something. It requires a request, an instruction, or a command. Doty simply loaned her car to Garst, right, to allow him to transport the kids. It was a kindly gesture, the dissent says, to basically help out Garst and the kids. The fact that she said he should drive was, as we all would see readily, that was a precaution that the car should not be driven by the boys because they're young, right? This was a natural suggestion or condition to say, hey, please do the driving, right? Don't let the boys drive. So the dissent says Doty loaned her car not for her benefit, but more for Garst's benefit or for the school's benefit, so agency should not result, right? Very interesting case. As I say, we might all sympathize with the dissent and say, yeah, that makes more sense. That's not the law, right? As you can see in this case, the court very well goes through the test of agency, applies the facts in this case, and comes up with an agency relationship. So that's Gordon v. Doty. Next case is maybe a little bit more complicated, right? The case is Gay Jensen Farms versus Cargill. I think we can start the case in this segment and we might finish it, or we might stop this segment and finish it up in the next one. Okay, so facts are a little more complicated here. A group of farmers in this case brought an action against Cargill and Warren Grain and Seed to recover losses when Warren essentially went under, right, when it went bankrupt. The plaintiffs won in this case, and Cargill appeals, right? So we're reading the appeal of the case when Cargill appeals because the plaintiffs win the case. Okay, so let's back up and talk about what happened here. Warren was a grain dealer, right? It also stored grain for farmers, and it sold chemicals, fertilizer, and storage bins. Warren applies for funding from Cargill, right? Cargill has ample resources, and Cargill agrees that it's going to help fund Warren. In return for making financing available, Cargill wants a few things, right? It got a right of first refusal to buy grain from Warren. So Warren and Cargill enter into contracts with increasing levels of financing, right? Cargill is providing more and more loans to Warren. Cargill is making these various loans to Warren in higher and higher amounts. Warren then agrees to give Cargill access to its annual financial statements, and it even says that Cargill could keep Warren's books, right, or get an audit by an independent auditor. So Cargill is looking for this information because it's making these loans and it's nervous, right? It wants to make sure it's going to be paid back. So it wants access to Warren's financial statements. And there's even this sense that Cargill, if they wanted to, could keep their books at Cargill's premises or at a minimum get an audit by an independent auditor. Also, there were some agreements like this. Warren could not make repairs over $5,000 without checking with Cargill, without getting Cargill's consent. So Cargill is keeping a careful watch on what Warren is doing. And there were other restrictions, right? Cargill was keeping very close tabs on Warren throughout their relationship. So as Warren's debts grew, Cargill told Warren that a regional manager would start to work with Warren on a day-to-day basis. Then it came out, as happens in all these cases, right, that Warren, in fact, had falsified its books. So Cargill obviously cut off financing right away. Warren now owes Cargill $3.6 million, and Warren owes the farmers $2 million, right? They're out $2 million. The plaintiffs sue, and they say, hey, Cargill is also liable, right? They're liable as a principal in a principal-agent relationship. And of course, that's very important for the plaintiffs because Warren went belly up, right? They don't have any resources. So the plaintiffs want to hold Cargill, who has deep pockets, responsible for what happened in this relationship. And the court essentially agrees, right? It starts with the definition of agency in the restatement. And the court says Cargill manifested consent that Warren would be its agent by directing Warren to implement its recommendations. By giving those instructions and directions, Cargill was really acting as a principal, controlling the agent, right? Controlling Warren. Next, the court says Warren acted on Cargill's behalf by procuring grain for Cargill, right? So they were acting as an agent on Cargill's behalf. And finally, Cargill controlled Warren, right? So remember, it's acting on behalf of another and subject to their control. And the court says, yeah, Cargill controlled Warren by essentially interfering time and again with Warren's internal affairs. And Cargill had de facto control over this entity, Warren. Constant recommendations, right, by Cargill. Cargill had a right of first refusal to buy grain from Warren. Warren was unable to enter into certain contracts without Cargill's approval. Cargill had a right to enter the premises, to enter into Warren's premises. Cargill, in fact, intruded into Warren's finances. Right? Cargill determined that Warren needed guidance. There was one fact after another showing that there was control. Now, the court says some of these might be also consistent with just a straight debtor-creditor relationship, right? Not a fiduciary relationship, not an agency relationship, just a lender relationship. But the court says we see that, but we need to look at the circumstances. Right? And the court says there was sufficient evidence in this case to show an agency relationship. So that's the case, right? Very slightly more complicated set of facts than in the first case, but hopefully you see why the cases come out the way they do, and this level of control was significant. I've got one or two more things to talk about with respect to the Cargill case. Indirectly with respect to the Cargill case, but I want to keep these clips relatively short, so I'm going to end this one now. When we pick back up in the last segment, hopefully the last segment, we'll talk for just one more second about Cargill and Warren Grain and Seed, and then spend a few minutes on Ottoson.